Welcome back, students. We're diving right into the next explainer for Evidence Law 1, brought to you by KMVTECH Education. So you've successfully wrapped up Module 1. We laid down the foundational meaning of evidence, its classification as adjective law, its history, and those 5 core objectives. Great job on that. But today we're taking a massive step forward. We are shifting from those foundations into what is honestly one of the absolutely most crucial concepts in this entire course. We're talking about relevancy. Think of today's lesson as your critical next step. You know what evidence law actually is. Now we need to figure out exactly what information a court is actually allowed to hear.
Let's take a quick look at our roadmap for today. First up, we'll examine the Kampala poisoning scenario. Second, what is relevancy? Third, facts and issue versus relevant facts. Fourth, the probative value test. Fifth, why relevancy rules matter. And finally, your Module 2 discussion question.
Section 1, the Kampala poisoning scenario. Okay, let's dive right into this. You know, to truly understand the law of evidence, we've got to see it in action. It's like a giant puzzle. So, I want you to picture a scenario currently unfolding in a courtroom. A woman in Kampala is on trial, and it's a very serious charge. She's accused of poisoning her husband. Now, the prosecution is obviously eager to secure a conviction, and they want to introduce 5 specific pieces of evidence. I'm going to go through these, and I want you to take a moment to carefully consider them. First, the accused purchased rat poison from a shop in Wandajia exactly 3 days before her husband died. Second, she had taken out a huge life insurance policy on her husband 6 months earlier. Third, she was seen arguing loudly with him the evening before his death. Fourth, and pay attention to this one, the prosecution wants to share that the accused actually failed an examination in secondary school 15 years ago. And fifth, the accused neighbor thinks she's generally a dishonest person.
So this brings us to a really critical crossroad. Look at those 5 points and ask yourself, which of these pieces of information should the court actually hear? Like, which of these facts genuinely help the court decide whether this woman actually poisoned her husband? And on the flip side, which of these are just noise? Maybe they're interesting to gossip about, sure, but do they have absolutely anything reliable to tell the court about what actually happened? This, right here, is the fundamental problem of relevancy. It's literally the very first filtering question that every single piece of potential evidence must pass before a Ugandan court can even consider admitting it.
Moving on to Section 2. What is relevancy?
So how do we filter out that noise? Well, we're transitioning now from our practical scenario over to the legal theory to find a solid filter for our Kampala case. We really need to define exactly what the law means when it uses the word relevant. I want you to write this down very deliberately in your notes. Relevancy is the logical connection between a fact and the matter in issue before the court. Let me repeat that, because it's absolutely crucial. It is the logical connection. A fact is relevant if, either all by itself or combined with other facts, it makes the existence of a fact and issue more probable or less probable than it would be without that fact. It's all about building that logical bridge.
Now, the Evidence Act Cap 8 actually doesn't define relevancy in just one single neat provision. Instead, it identifies categories of relevant facts across several sections. However, the foundational provision governing what a Ugandan court can hear is Section 5. It states, and I quote, "Evidence may be given in any suit or proceeding of the existence or non-existence of every fact and issue, and of such other facts as are declared relevant by the Act." Write that down. This is your statutory anchor for this entire module.
Section 3. Facts and issue versus relevant facts. Now, what's really interesting about this slide is that it introduces a distinction that trips up so many law students, but it's absolutely vital for your understanding. To grasp relevancy properly, we have to completely separate facts and issue from relevant facts. Let's contrast these two concepts. On the left, we've got facts and issue. These are the specific things a party absolutely must prove or disprove to win their case. They arise directly from substantive law. For example, in a murder case under the Penal Code Act, Cap 128, the facts and issue include whether the accused caused the death, whether the death was unlawful, and whether there was intention. These are the ultimate destinations the prosecution has to reach beyond a reasonable doubt. Then on the right, we have relevant facts. Think of these as the logical stepping stones. They aren't an issue themselves, but they logically connect to and help prove the facts and issue. Let's anchor this right back to our Kampala scenario. Buying rat poison is a relevant fact. Buying rat poison isn't a crime itself, it's not a fact and issue, but it makes it more probable that the accused had access to poison, which makes it more probable she could have used it. Now, the failed secondary school exam from 15 years ago, that has absolutely no logical connection to poisoning someone. It is an entirely broken stepping stone.
Section 4. The probative value test.
So now that we know the difference between the ultimate destination and the logical stepping stones, we need to look at the mechanism we use to determine if one of those stepping stones is actually relevant. Like, how do we test it? Well, the crucial point here is that the test for relevancy is a strictly logical one. You always have to ask, does this fact, if true, make it more or less probable that something an issue actually occurred? This is what we call the probative value test. We are asking if the fact logically moves the scales of probability for the case. Does it prove, or even tend to prove, something that actually matters?
The outcome of this test is binary, and honestly, pretty straightforward. If the answer is yes, meaning the fact has probative value and moves the scales of probability even just a little bit, then it is relevant. If the answer is no, if it doesn't move those scales of probability in any direction on any issue whatsoever, then it's irrelevant. And if it's irrelevant, it must be excluded. No way around it. It cannot be admitted.
Section 5. Why relevancy rules matter.
At this point, you might actually be wondering, why do we even need this strict rule in the first place? Why not just let the judge hear absolutely everything and decide what's important later? Well, let's examine the 3 core purposes of relevancy rules and why they are so essential to the justice system. First, relevancy is the first gate. Before a court even asks if evidence is legally admissible, it must ask if it's relevant. If it's not relevant, it's blocked right at the gate, regardless of how reliable it might be. There is simply nothing for it to prove. Number 2 is efficiency. Imagine if courts heard every single piece of information a party wanted to introduce. The proceedings would drag on endlessly. Relevancy keeps trials manageable and focused on what actually matters. Third, and perhaps the most important one, is fairness. Allowing a court to hear that an accused person failed exams 15 years ago, or that a neighbor thinks they're just generally dishonest, that risks the court's decision being influenced by prejudice rather than actual proof. Relevancy filters out that prejudicial junk and protects the integrity of the whole trial.
All right, get your pens ready. You are going to need to take down these vital citations for your notes and for sure for your future exams to back up everything we've just discussed.
First up, we have the Evidence Act, Cap 8, Section 5. As we just discussed, this is the foundational provision allowing evidence of facts in issue and facts declared relevant. Second, note down the Evidence Act, Cap 8, Sections 6 through 16. These sections identify specific categories of relevant facts, things like motive, preparation, and subsequent conduct. Finally, make sure you note this persuasive 1894 Commonwealth case, Makin versus Attorney General of New South Wales. This foundational Privy Council case establishes that evidence of similar facts may be relevant where they show a system or pattern connected to the matter in issue. Ugandan courts frequently cite this as persuasive authority, so you'll want to remember it.
Section 6. Module 2. Discussion question.
Let's see how all this builds your analytical skills by returning to our opening scenario for your final homework assignment. I am leaving this provocative discussion question up on the screen for you to ponder. I want you to apply the probative value test we just learned to those 5 pieces of information from the Kampala poisoning scenario. Which one should the court admit and why? For each piece you exclude, explicitly explain what makes it irrelevant. And finally, I want you to specifically ponder this. Is there any circumstance under which the neighbor's opinion that the accused is generally dishonest could ever become relevant to a criminal case? Think critically about the scales of probability. Good luck with your analysis, students, and I'll see you in Lesson 2.